For me, it's just important to remember and keep this in mind when we look at the performance improvement policy. Just think around that sort of three-stage, and the dialogue is going to be really important when we look at the new performance improvement. So in terms of the overview of the improvements for all of our policies around the modernisation is making sure we're using consistent language. So again, we have worked closely with OD to make sure what they're building into the performance management framework is replicated in the performance improvement. So again, we're speaking the same language. We don't want to confuse you with what is a performance management discussion language and then all of a sudden a formal performance improvement process. So we're trying to be consistent, making sure we're up to date with current legislation and changes in legislation that's coming through. Looking at consistency, so if we look at the four policies, we had some were timescales were in calendar days, some were in working days, some had 5 days, some had 10, some had 7. So for each policy, there was a slight difference in terms of the timescales. So actually, you really did have to keep checking back in on yourself to say which policy am I working with, therefore what are the timescales. So what we've created is the timescales are consistent across all of our policies, and they're all in working days as well. So it's just little things like that that make it easier for you. Looking at best practice, so we have worked and looked at other authorities, we've looked at private sector, we've worked both internally and externally with solicitors. And the other thing is making sure they're portable. So, can an academy adopt these policies and is it appropriate for academies? So, that is something moving forward with the conversions that are going through with our academies. Also with our colleagues in trust, is this something that they might want to implement and take on board? Which is why we're looking at making sure they're portable. Shorter and far more how-to information. So we've, in the previous policies, we've hidden all the how-to and the toolkit in the actual policy, of which you do have to go end to end to find it. Whereas now on the internet, you will find template investigation report, you will find a suspension letter. So things will be far quicker for you to be able to find on there. And what we are looking at in terms of the improving the success of the policies is we want to change the behaviour. So throughout all of this, you will see, and we're talking to more things around addressing things at the local level, not escalating things up, trying to nip things in the bud and deal with it informally, as opposed to forcing people into the formal processes. We've looked at removing the unnecessary steps and procedures. So again, this is where we're inconsistent, but some parts of the authority, when an employee appeals, the chair of the disciplinary hearing then has to prepare a complete report, then has to attend the appeal hearing and almost justify why did they deliver the sanction that they did. That's unnecessary because the actual appeal hearing manager needs to make that decision themselves. So unnecessary steps as well were we tended to invite all the witnesses, and actually we only really need to have witnesses there where there is a dispute around their statement or our colleague wants them there to be able to ask them questions. So we've tried to streamline some of those. Asserting accountability, again, it's making sure, as Helen talked about, as line managers, you are responsible and accountable for managing your people. Not just the process, but managing your people. So it's making clear on that. And as HR professionals, we are here to advise you. You don't have to take our advice. We will advise you, and we will, put in terms of mitigating the risk or what the risk is. But ultimately, as line managers, it is your decision as to what happens next. Reducing the number of the roles. So again, if you take the disciplinary, we have at a hearing currently, or up until yesterday, we had the chair, we had the presenting officer, which may or may not be the investigating officer. We have a HR advisor to the chair, we have the colleague, we have their representation, we have all the witnesses. We were seeing some disciplinary hearings taking anything from 1 day to 3 days. We created almost a judicial process where it was a mini employment tribunal that we were running through, when actually it needs to be more of a conversation and a discussion around the evidence than people coming in and reading their witness statements. I think we're all capable of reading and forming judgments from that. So again, we've reduced the number of people who are involved, and we'll talk about that a bit more. And again, just making sure we are up to date with ACAS best practice and in line with sort of any legal changes and compliance that we need to do from an employment law position. So if we move on to the roles and responsibilities, and these are generic roles that will apply to all of the policies. So we've tried to create consistency and calling the roles the same throughout, whether it's a bullying, harassment, grievance, disciplinary or performance improvement. If we look at the deciding manager, this is the person that is appointed at the beginning of an issue. So if, for example, we take a situation where you have got somebody who has been persistently late and they've already had an informal discussion to say this isn't acceptable, I do expect you to turn up on time. Next time you are late, it may lead to formal disciplinary. You appoint a deciding manager at the beginning of that. They will review and have, they will normally be, in the lower level stages, they will normally be the line manager. So they will, if it is a persistent lateness, they will identify that I've already spoken to Fred about this situation, documented it and made him clear of the consequences if he's late again. And then that deciding manager will say, actually, do I want to deal with this informally and give him another chance, so another conversation, or do I believe now we need to move into an investigation because it needs to move into a formal, because I don't believe he will change his behaviour unless we move into a formal procedure. So it is the role of the deciding manager to instigate that and decide whether they can deal with it informally or does it need to go into an investigation. So obviously if it is a potential gross misconduct, we would move straight into the investigation stage. If the deciding manager believes that actually we do need to carry out an investigation, they will appoint an investigating manager, as we do currently. For lower level issues, so if it is around timekeeping, lateness, the investigating manager may be the deciding manager as well. But what I would say is just speak to your HR advisor and they will work through with you in terms of what is the allegation and therefore who is the most appropriate to be the deciding manager and also be the investigating manager. They are responsible for the end-to-end process. So the deciding manager will instigate the investigation if appropriate, and they will ultimately take that to the decision of what happens with the sanction if there is a formal process to be taken into account. I think where this is slightly different, and again, different parts of the authority deal with this differently. Currently, in some areas, the investigation manager actually makes a recommendation at the end of their investigation report in a disciplinary situation to say, I believe this is gross misconduct and therefore should be dealt with under disciplinary, or I believe this is a stage 2. The investigating manager's role will now only be to collate the pure facts. It will be up to the deciding manager to read the investigation report and say, actually, yes, I do believe we need to move into a formal process, and that's either stage 1, 2 or 3. So I think that's slightly different from where we are now. The deciding manager will take responsibility to organise the hearing, whether that's a grievance or a disciplinary hearing, and will chair that hearing and also make sure the appropriate administration of note takers are there. Depending again on manager's experience and the level of the hearing, it is whether a HR advisor is there, but 9 times out of 10, a HR advisor will be present to support the deciding manager in those formal hearings. And ultimately, it is the deciding manager to make the decision of, is there a sanction, and therefore what is the sanction? If we look at the investigating manager, once the investigating manager is appointed, they just need to clarify with the deciding manager what is the remit of the investigation, what policy is it? Is it under grievance? Is it under disciplinary? They will obviously carry out the investigation in line with our new investigations policy. So we have pulled out the investigations out of all of the different policies to create one procedure. So again, it's consistent whether it's a grievance or whether it's a disciplinary situation. Big change here is we are aiming for our investigations to be concluded within 40 working days. This is a challenge as it stands now at the moment. We have got investigations that have been going on for 3-4 plus months. And what we are looking at creating, and our HR partners are working with WLT members, is to create a pool of investigators from across the authority that we can pull on, which will hopefully be able to not free up their day job at all, because that's unrealistic, but will hopefully be able to probably more focus on the investigation to conclude it quicker. We'll also provide training for those people. So again, at the moment, it is a skill to carry out an investigation and write up a report. We will be providing a workshop. And so some of you may get nominated by your SLT and WLT members to attend that. But what we're trying to say is actually, if we focus the efforts, we will actually get things concluded far quicker, and it'll be far more cost effective than if we try to prolong it over 3, 4, 5 months. There's a lot of indirect costs associated with the employee in the middle who is being investigated. If they are at work, their performance will drop, their motivation will drop, the impact on the team members And also as well, if you're having to refrain them from doing certain duties, it's a bit of a false economy if we can't focus in on that investigation. The investigation manager will produce the report, and it will be purely facts. So what are the facts that I have investigated? What is the evidence? And there will be no recommendation on there. And they may be required to attend the formal hearing. I would say that should be the exception rather than the norm. We're getting to the position where we want to get to is the investigation report is comprehensive, that the deciding manager can read that, have the meeting with the colleague and their representative and make a decision based on that, is where we're aiming to get to. So again, it's almost creating that one meeting with those three people around that table. If we look at the appeal deciding manager, it's very similar to the deciding manager. It purely is that if a colleague appeals whatever the sanction or the stage of the policy, somebody independent will be appointed as the appeal deciding manager, and again, they will arrange for the hearing, they will hear the appeal, and they will make their decision based on that. There is no requirement for the previous deciding manager to do a report or to attend unless there is some issues that you need to investigate. It will be a discussion, and we are putting more emphasis on the colleague to specify their grounds for their appeal. So it is around, is there new evidence? Is it that we failed to follow procedure, or is it that the sanction is far too severe, and based on what evidence? And finally, human resources. We are here as professionally qualified HR professionals to give you the advice, to identify the risks, and to support deciding managers throughout the process. We will support you through investigations as well, and it will be very much for us to give you the advice and for you to make the decision based on what you have heard, what you have read, and what advice you have been given by your HR advisor. And I think one of the things just is always worth, and this is just a real reminder to us all, and it is difficult at times in terms of where does certain things lead to which policy. So looking at this in terms of performance stroke capability, this is absolutely a lack of skill or ability. So they haven't had that skill. The job may have changed and evolved over the years, and they've never done that before. So they need development, training, sitting next to Nellie kind of support. Whereas the misconduct, which is dealt with purely down the disciplinary, is around they've got the skill, but it's actually the will. They don't want to do it for whatever reason. And it can do it but won't do it. And it's all about their choice. And I think this is just one of those, sometimes we end up going down performance improvement route when actually it is a conduct, because they have they've demonstrated before they've got the skills, they've got the ability, but for whatever reason they've chosen not to apply those skills and that ability. So that for me, that's just a reminder to say which ones do we deal with under misconduct and which one is genuinely performance. And I think probably one of the other sessions I did, the caveat on that would be, just because somebody has done it in the past and isn't doing it now doesn't mean it's an automatic misconduct, because there could always be circumstances outside of work that has impact on them that just means for whatever reason they're not able to do that at this moment in time. So it's important to try and just fact find a little bit before we jump down the misconduct or the performance route. So if we look at the performance improvement policy, which I think realistically the capability policy we've had the most feedback on in terms of it's timely, it's costly, it's labour intensive, I don't bother doing it. And we have had in the last 12 months 0.01% of our population go through the formal capability policy. The norm, if you look at the typical Bell distribution curve, is you would normally have 5% at any one time going through performance capability. We are significantly off that. Some organisations always force their bottom 5% through, whether they are achieving or not. They continually churn that bottom 5%. That's absolutely not what we're looking for, but we need to make a step change in terms of how we manage our people who are not performing. So in terms of the informal, it is very similar to what you do now. So it is around making sure the colleague is aware exactly what is the expectations, what are they meant to be delivering, agree an action plan. Again, we'll have action plans on the internet for you to use that, capturing the critical information that you need on there. Identifying what support, what training is required. Is it that they just need to shadow somebody? Is it they need time from you as a line manager to show them something? Is it they do need to attend a formal course to get a formal qualification to do their job? Or is it that the job has changed and they just need to understand the new processes and ways of working? It is critical, as Vaughan has talked about monitoring and reviewing those. The dialogue is very important. When we get to the formal process, I think the paperwork will become as equal importance because that's our evidence. But for this, it's around making sure you monitor, review, and give regular feedback, and give that feedback in the moment. So if you spot them doing something that is not right or against what you've agreed, you deal with that straight away. Don't wait for your next review. Sorry if I'm teaching grandmothers to suck eggs. But it is really important about that regular and in-the-moment feedback. Keeping appropriate records. I think this is probably where the frustration comes in. The current policy is you deal with it informally, you come to HR and we go back through the informal process before you can get into the formal process. The record keeping is important, but it is around the audit trail. So we can identify what is the skill, what is the gap, what do they need to do to close that gap, what support do they need, and over what time frame are you going to review that. As long as you can demonstrate and evidence that you have agreed these actions and you have reviewed them, you have supported them where they needed the support, that is the information that we're looking for. And it is about two-way feedback, so part of the performance management discussion is around ensuring that the colleague gives you feedback as well. The difference in the informal performance improvement is there is no time. So this is going to be determined by you as line managers. If you need to identify what is the skills gap, what's their experience, have they done it before, and you work with your individual to say, actually, I believe we should see an improvement within 4 weeks, 6 weeks, 8 weeks, 10 weeks, whatever that is. There is no specified time frame where you have to stay within the informal procedure. So this is all about, you know the job, you know what they're capable of, and you know how you can bridge that gap, so you make that decision. And then we look at how do we transition then from the formal transition to the formal performance improvement. If you take the informal action around, timekeeping, somebody that's not taking their 30 minutes lunch after you've already had that conversation with them 3 times, line manager can make the decision to say, actually, I will have a conversation with them to tell them that I expect them to attend work from 9 o'clock till whenever, and I don't expect them to be late moving forward. You may need to agree an action plan for something if it's minor, or you may just want to say, actually, I'm just going to review this. I don't think I want to have a word with them now. I'm just going to review this and monitor this situation, to have this conversation with them. The one thing that's really important to note is that under the new disciplinary policy, there is no letter of expectation. So that has been removed, and it's purposely been removed. The letter of expectation was originally designed for these informal discussions. So you would have a discussion with somebody around their timekeeping or how they've spoken to somebody, and you would actually say, I don't expect you to talk to somebody like that. My expectations are, and you would issue that letter. What's happened and evolved over time is the letter of expectation has become a sanction coming out of a disciplinary. So we're having disciplinary hearings and the outcome is a letter of expectation. And that should never have been happened, because the outcome of a disciplinary hearing can either be no sanction, first written warning, final written warning, or dismissal. It's never been a letter of expectation. So it's evolved and has become quite a beast of a thing that we just need to stop that. What I would say is the content of a letter of expectation in terms of, we had this discussion, you did this, we've agreed this, I don't expect to see this happen anymore. You still need to record, and that can be done via email, that can be done on your one-to-one documentation, your supervision documentation. You can record that anywhere that you have had this conversation. These are what you were doing, this is what I expect you to see, but don't put it in a letter and don't label it letter of expectation. Because the other challenge we have with a letter of expectation is an informal, and we are making it formal by putting it into a letter. So do it by email, do it by your supervision notes, your one-to-ones. So as of yesterday, no letter of expectations should be issued. Where are we? So in terms of formal action, this is very similar to it is the same as it is currently now. So there will be The deciding manager will review what's happened, the incident, the complaint, whatever the misconduct has been. And again, they'll decide, as we've talked about earlier, is there no action required? Do we need to move into formal? Again, do we need to suspend? Is this a potential allegation of gross misconduct and therefore suspension is required? We have now got a separate suspension procedure. So in the past, the suspension can only be enacted via a disciplinary route, whereas now we can suspend based on bullying and harassment claims, on grievance. So we suspend where we deem it is appropriate. It's still a neutral act, and it's around protection of the individual who is being suspended, protection of the evidence, or in bullying and harassment claims, it could be protection of the people making the complaint. We carry out the investigation, as we do currently. The deciding manager then will decide to say, actually, do we need to hold a hearing, which we've already discussed about. And again, the sanctions in a formal disciplinary policy is stage 1 is a first warning, which again is 6 months, so we've got no change there. Stage 2 is a final written warning, which again is 12 months, and stage 3 is dismissal. We are at all of those stages, as we do now, and as under employment law, they have the right to appeal. And then that will go to an appeal deciding manager, as we've talked about in the roles. I think on this point, in terms, we've talked about what the format of the meeting is, so it is trying to reduce the numbers of people attending that meeting. The employee colleague has and always has got the right to call witnesses, but we would ask them about what is the relevance of those witnesses, as to whether it is appropriate or not. So again, we're just trying to reduce the numbers of people involved in that. And again, in terms of HR advice and presence, this will be very much determined by the deciding manager. Is it a low-level stage 1 that you've done 50 of them and actually I don't need any advice? Or actually is it a complex case where I absolutely need a HR advisor there? In the policy, it says where appropriate. So it will be down to you as line managers in terms of what would you do. My view is we would never dismiss anybody out of Staffordshire County Council without having a HR advisor present to give you that risk, to give you that advice and the consistency. Because one of the feedback we've had from yourself as line managers is that the advice you receive from HR can be inconsistent at times. And I think some of that is born out of how I've talked about previously. We worked under the old directorates. Some of it is purely down, we will never ever get 2 situations that are the same. You know, we are all human beings. We all react to situations differently, respond to situations. So we are trying to be as consistent as we can. But again, how people conduct themselves during an investigation, during a hearing, can influence the outcome. So if I take an example, if you have two colleagues that have done exactly the same thing, and it's a stage 3, for example, if it's gross misconduct or stage 3, and the one colleague comes in and is like, I know I shouldn't have done that, I'm really sorry, and is very remorseful about what they've done. You might, as a deciding manager, say, actually, they know what they've done, they appreciate that they've done this, they've supported throughout the whole of the investigation. Actually, I want to issue them as, at the final stage, written warning. And the other colleague may come in, has got no regard for the process, hasn't supported, hasn't helped, absolutely doesn't see what they have done, and therefore the risk of them doing it again is high. And you might make the decision as a deciding manager to say, actually, the risk of them doing it again because they don't recognise what they have done is too great, therefore my decision is to dismiss. So we will never get that absolute consistency, but we are working in terms of our case team who will support you on these policies. That is now a smaller team headed up by one senior HR advisor. So again, we're working really closely with one another to make sure we try and share our best practice, share our learns throughout the HR team. Grievance, this is the policy that has changed the least. So this will be very familiar to you all. Stage 1 is the informal. So again, this is where we are asking colleagues to come to you as line managers to say, I'm not happy about this, or I've got a problem working with Freddie or with Flossie. Can you help me to work through this? One of the things may be, if it is where you have got 2 members of your team who are not working together for whatever reason, mediation is available to them if they're both parties are wanting to do that. And this is about asking, it's not about the colleague coming to you and saying, I want you to resolve this. It's asking them about what outcome do they want, what do they want in terms of resolution for themselves. And if somebody raises a stage 1, just making sure that if you have resolved it, you monitor that to make sure that continues. If they believe you haven't resolved it, probably to their satisfaction, or you're unable to resolve it, they then have the right to move that to a formal stage 2, which is what they currently do now. And again, we will, at a stage 2, it becomes formal, so we will have the formal meeting where we will appoint a deciding manager who will probably investigate it as well. So you would arrange for a meeting with the colleague, their representative, discuss their grievance, identify what it actually is. You may be able to make a decision on that day to say, absolutely, I don't know, we've changed a way of practice in working, that's how it is, we're having to comply with legislation, so I can't change it back. The outcome is that I don't uphold your grievance. Or it may be that you just need to find out some further information, and therefore you would adjourn that meeting, go away, investigate, and then reconvene and give them the outcome. Again, within all of these, the outcomes could be that the whole grievance is upheld, partially the grievance is upheld, or you do not uphold the grievance. At stage 2, again, they have the right to appeal. So if they are not happy with the outcome, and whether it's down to there's new evidence, they believe that you've failed to follow with the process, they will then raise that at a stage 3. Currently, those stage 3s go to Nick Bell. Again, all of this will be in line with somebody more senior or more appropriate who has made the stage 2 will hear the stage 3. So in most parts of the authority, it will be a hierarchical escalation. For some areas where it may already be at, for example, a WLT member, we may want to go sideways so we don't bring SLT in, or if it's an OMT, we might want to go to an independent OMT member before we raise it up to WLT. But again, each of those will be advised through the HR advisor through the scheme of delegation. Stage 3 is the final stage. So again, once you've got to a stage 3, you have no right to appeal. The one thing that has changed within the grievance policy is where we currently had an extra stage, stage 4, in for collective grievances. That has been removed. So individual and collective grievances will be dealt with in exactly the same way through the 3-stage process. Beth? Very good question. Mediation, I understand, was launched a number of years ago, of which we had a blend of HR and business representatives in the mediation pool. We have seen mediation has worked, so it's a really good thing in terms of we have managed to resolve a number of what could be grievances through mediation. The challenge we've got at the moment is that HR are predominantly doing all of the mediation. So we're currently reviewing, we had a conversation with Chris today, haven't we, around the mediation. We are going to review our process, and therefore we will be coming back out at some point to say actually who within the business would be interested in becoming a mediator and create that pool again. I think it's lost its momentum and it's just been driven directly through to HR. And again, one of the things we are promoting throughout all of our policies around mediation, informal, try and resolve things without moving into formal process. So I think we do recognise that the mediation process can be quite clunky. So it can take up to a day, day and a half of your time. What we're trying to do is get to a point of it's a 2-hour meeting. If you can't resolve it in 2 hours, you're not going to resolve it. And therefore we'll have to deal with it formally. So there will be something else coming out on mediation over the next sort of couple of months. Probably just to make you aware of all of this is we are reviewing the scheme of delegation as well. So we've got, I think, various schemes of delegations across the authority. We are trying to work with Tracy Thorley and John Tradewell to create a new scheme of delegation, which hopefully that will be out shortly. And what we are trying to do is get to a position where we just say, because of trying to support the dealing with things informally, we will just get to a position where we say a certain grade is able to dismiss under our HR policies. So again, trying to remove it away from the hierarchy is it must be a WOT member, it must be an OMT member. It needs to be somebody who is appropriate more than the status. But I appreciate we do have a scheme of delegation on that. And then moving on to the 4th and final policy, bullying and harassment. This policy has probably changed more to be a statement of what is and not acceptable within Staffordshire County Council around bullying and harassment, as in we do not tolerate bullying and harassment within Staffordshire County Council. And this is probably the biggest change, to say actually if somebody wants to make a bullying and harassment claim or complain about bullying and harassment, again, informally we would try and ask them to deal with it in their line manager. So if it is a colleague that they are making a complaint against, we would ask them to sit down with their line manager and try and deal with that. And again, this is where mediation could really work and has worked in the past, to say actually it's a clash of personalities more than a bullying and harassment. And again, it will be up to the line manager to try and resolve that informally, monitor and make sure that continues. If it's not resolved, or if it is, for example, regarding making a bullying and harassment claim against their line manager, we will actually make that as a complaint and it goes straight into the grievance procedure at stage 2. So at the moment, the bullying and harassment policy has its own process that it needs to go through, which takes about 55 days to complete a bullying and harassment investigation under the current policy, which 55 days for somebody or a group of people who are being potentially subject to bullying and harassment is not acceptable. So what we've tried to do is remove all of that, go straight into a grievance, which you will hear no later than 10 days, and try and get that resolved quickly. And again, this is where the suspension procedure will come in of actually somebody's made a bullying and harassment claim, they've gone to stage 2 of the grievance. It is appropriate for us to remove the alleged bully, alleged harasser out of the workplace.
Does it have to be the bullied that makes the bullying and harassment claim? Because obviously in that position they feel very vulnerable about making a claim like that against another member of staff. And could it be a line manager that actually says you're being bullied?
Yeah, as line managers, you all have responsibility that if you identify or see bullying and harassment, you need to deal with that. And whether that's informally or whether actually you can investigate that and almost miss out the grievance, but you investigate it and deal with it through disciplinary, they can raise them through their union, through any representation as well. So we have had bullying and harassment claims that have been coming collectively from the union. We as a HR function and you exactly as line managers, that if we are aware that people are making complaints, whether it's informal or formal, around bullying and harassment, we have an obligation to deal with that appropriately. We can't just say, actually, you either put it in writing or I'm not doing anything about it. We actually have an obligation, and that's something, if we are on notice of bullying and harassment happening within our team or within a function, we have to deal with that. And that could be that you just straight away instigate an investigation into that. If you've witnessed it, then obviously you've got some evidence of that. Some of it, I guess, sometimes we find it is purely a clash of personalities, so through mediation we can resolve that. We are seeing a number of bullying harassments, increase in bullying harassment claims. And on the flip side of that as well, we're seeing a number of bullying harassment claims that are being upheld. I think in my 20-odd years working within HR, I've probably seen 2 or 3, and we've had quite a number over, I'd say, the last 6-7 months.
And what do you see of the number of cases that come about because of other policies being put into line by line managers? Claims of this coming back to line managers?
So, if we take, for example, the performance improvement policy, there is a sentence in there that says, in the bullying and harassment policy, there is a paragraph in there around, this is me paraphrasing it, but basically, your line manager managing your performance does not constitute bullying and harassment. And that's where you see the vexatious, frivolous claims are born out of somebody's being performance managed and they've never been managed before for the last 3 years, 6 years, whatever it is. So again, in the bullying harassment, if they make a vexatious claim which is not upheld, that's a disciplinary. We have to prove that it was vexatious because, again, bullying harassment is about how it made that individual feel. But if absolutely it was a result of they've been undergoing a disciplinary or under performance management and we've got evidence, we will deal with that through a disciplinary. And some of that is we are seeing the increasing number where we are managing performance more proactively and people haven't been used to that. So it is a natural reaction of not being used to having that direct instruction that actually that's bullying and harassment, and it isn't. And we've had it through managing attendance at work as well. People are saying that's bullying and harassment. It's actually, no, it's effective management of our resource, which is our people. But we have absolutely put that in the policies about this is what it isn't. Is there any questions around that? So hopefully this will be a lot easier to understand than currently where you have to put in the claim, you have to investigate it, they have 15 days to review, everybody involved has 15 days to review the report, they then have 40 days to appeal, it's got to be signed off by a director, which is all very complicated. Okay, so we are getting into the last few slides. I think I talked about this very early on in terms of trying to create the consistency. So what we've got is in timescales for all of our policies are consistent throughout. When we're dealing with informal stages, whether it's a grievance, whether it's performance improvement, or whether it is disciplinary misconduct, it's up to the line manager to set that timescale. So it needs to be appropriate and proportionate to whatever you are asking them to do. So if you are asking them to become a brain surgeon within a week, that's not acceptable. But if you are asking them to attend work on time, 24 hours is probably quite a good time frame for you to review that. Once we get into the formal stages, all of the invite to any formal meetings must be 10 working days. The outcome of any formal meetings must be confirmed in writing within 10 working days. If people are not able to attend the formal meeting, they have 5 working days of which to rearrange that. And this is something that's really important that we're capturing around why are we rearranging, because some of this is what builds in the time delays, where the colleagues say they can't attend or the representative can't attend. There is absolutely in the policy, which everybody signed up to and the unions have signed off to say, we will be and make ourselves available within 5 days of that original meeting. So if you are getting challenges and issues where people are not being able to attend, you need to flag that to your HR advisor straight away. Investigations, where applicable, will be completed within 40 days. As I say, we are significantly off this at the moment, and we will be working with all our line managers to try and condense that time frame to deal with that. And hopefully some of the removal of layers and everything will help with that, and creating an investigation pool of both internal and external, probably more experts, will hopefully reduce that timeline as well. And anybody wishing to appeal, again, must appeal within 5 working days of them receiving the outcome. So that's just creating the consistent timescales. And just in terms of their right to appeal, they have a right to appeal at any formal sanction. So again, a right to appeal once we get into stage 2 of the grievance and any disciplinary. They will always be invited to an appeal hearing, and that will be, who will do that is the appeal deciding manager, and how they will decide and hear the appeal will be through arranging that meeting. And the one proviso is that the outcome of any appeal can be no worse than the original sanction. So unlike stocks and shares, it can't go up as well as down, of which probably everybody's going, oh. When I did this in Families First, I had a bit of a boo and a hiss on that one. But it is important because the essence of we need to make sure we're getting our investigation right. If new evidence comes in, that should only have come to light after the investigation. You know, I'd hope that through a thorough and fair investigation, we will have ironed out any contrasting statements or any arguments in statements or any new evidence that comes to light. But human beings are human beings, that all of a sudden they remember something they should have told us 3 months ago and hasn't. So we just need to build that into there. And that is that in a nutshell. Are there any questions arising from that? As I say, all the policies are on the intranet now, so please go have a look. Hopefully not many of you will have to use them, but I hope when you do use them that you'll find them probably more user-friendly and easier to understand.